With a slew of activists, prominent community leaders, and others trying to save Duane Buck's life, one legal expert says on this case they have no legal ground to stand on. Former criminal defense attorney and death penalty expert Jim Skelton joins us live by phone to weigh in on this case. Are you surprised that the Supreme Court agreed to take Buck's case?
Yeah, I really was surprised because like 2 days ago they turned it down. I was surprised, yes.
What has people upset about this particular case?
Why are they upset?
Yes.
I think they don't misunderstand a lot of it. Let me explain what happened. All this revolves around the testimony of a psychologist named Walter Quijano. Quijano used to be the chief psychologist for the Texas prison system, and he had testified in some death penalty cases for the state. And what he did, he had devised a 24-factor test to determine whether or not somebody would be a future danger to society. One of those factors was race, and he used factors such as gender, like, for example, females were less likely to be a future danger than males. He used age, like young people are more likely to be violent than older people. And he also used ethnic background, and his conclusion was that if you were an African-American or a Hispanic person, you'd be more likely to be a future danger because there's a disproportionate number of those ethnic backgrounds in prison. So he testified in like 7 different cases. There's a case called Soldano that was reversed by the U.S. Supreme Court back in 2000. And in that case, the Attorney General confessed error, saying that we should never use race as a factor in determining future danger. After that case was reversed, there was a press release by the Attorney General saying that in future cases, when they come into federal court, we're going to confess error and will not object if these defendants get new trials. They identified 6 cases in which Quijano had testified. Now, what happened, in 5 of those cases, the Attorney General confessed error, and then retried again. However, on retrial, every defendant received the death penalty again. Buck's case was entirely different from the other 5. The reason being, in Buck's case, it was the defense, not the state, who called Quijano as an expert witness. Mm-hmm. And in Buck's case, unlike the other 5, Quijano testified Buck, would not be a future danger to society. But the defense also brought out that one of the factors that Dr. Quijano used was race. All the state did when Quijano was passed on cross-examination was ask one question. They simply followed up what the defense had asked. Was race a factor that you used? And he said yes, and that was it. It was never mentioned again, never argued again by either side. And the reason Buck's case was different, because in Buck's case, Quijano testified he would not be a future danger, and as prior cases they testified that the defendants were. And in this case, it was never, like I say, it was never mentioned again. The race factor was never mentioned again. It was not emphasized at all.
Well, Jim, what does this case say about bias in the Texas legal system?
Well, to say that there's not bias in the Texas legal system is insane. There's always been bias and not only in Texas, throughout the nation. For example, there's bias when we walk down the street. For example, if you're going down a dark street and you see 2 white kids approach you, is your reaction the same if it's 2 black kids wearing hoodies? And the answer is no. And it's bias is there, and to say that there's no bias in our system is nuts, because there is bias in our system. There's bias in our society. But in this particular case, to argue that he was given the death penalty because of this one sentence is nonsense, in my opinion, is nonsense, because you got to weigh it against the fact that he went into his ex-girlfriend's house with 2 rifles, shot at one man and missed him, confronted a man in the house, shot and killed him, shot his own sister in the chest, and then chased his ex-girlfriend down the street and shot and killed her in the presence of his 2 teenage kids.
Right, a 14-year-old daughter and an 11-year-old son.
And then when the police get him, he laughed and said the bitch got what she deserved. That's why he got the death penalty, not because Quijano said that because Quijano said he wouldn't be a future danger.
Right. Well, even if the sentence of guilt is right, does the punishment meet the crime?
I'm against the death penalty, so I'd be biased on that particular case. But it's going to be difficult. Well, in this case, when somebody is in a rage and kills somebody, the likelihood of them being a dangerous future, in my opinion, is not as great as somebody who does a cold, calculating killing. So I'm pretty biased about that, because I'm against the death penalty, and I would vote against future dangerousness. But I can certainly see why a jury would think so, because after all, shoots his own sister, kills 2 people, and shoots at another person.
Pretty cool.
I can see why they would do that. I would just, my opinion would be different.
Well, Jim Skelton, I know that you're getting ready to be on execution watch, which of course will be right here on KPFT 90.1
well,
FM
we'll
at 6
see,
p.m.
because, Scalia's we don't know whether Scalia's going to grant a stay or not.
Counting on that wild card, huh?
Well, that's a pretty wild card. Under the law, now the only reason I think they'd grant a stay because this case has the appearance of being unfair, and courts are real concerned about, appearing to be fair, and they may grant a stay simply based on that. I don't know.
Very
that
interesting.
Would be there's no legal basis for it, but there's a basis for it in that sense.
Well, waiting for Scalia again. Jim Skelton, thank you so much for joining us.
You're more than welcome anytime.
Thank you, sir. Again, we have been talking to Attorney Jim Skelton. He is an expert on the death penalty, and you can hear him here every time that the state of Texas has an execution on Execution Watch right here at 6 p.m.